So we're going to turn to the question and answer portion of this presentation. So if you haven't already, please feel free to submit your questions in the chat and we'll go ahead. Let's see, we've gotten a lot of questions already, so I'm going to kick it off with this one. So this might be directed to you, Ron or Ken. Under what circumstances can children receive SSDI? So for example, if the parent is on disability or has died, may the child receive benefits as well?
Yeah, it's a complex sometimes question on that. And first off, so as Ken's slide had broken down, SSI and SSDI are the two programs. An easy way to think about the difference is SSDI requires work quarters to be paid in on the private sector. So a quick rule of thumb is if someone has worked 5 out of the last 10 years, they would be eligible for SSDI. So that answering the question, what circumstances for children? So a child does not have to work in order to get or apply for disability and end up with it. But just know that that's going to be an SSI case only. There's some exceptions, and I've been brushing up on this recently as well. There's a disabled adult child exception to this rule where if a person is found, you must show that they're disabled before age 22, but you could apply for SSDI for a child if their parent is retired and receiving regular social security retirement. And the other part of the question was survivor benefits, which is another sort of complex area we could talk about all day. In a simple way, if a person, their parent has died, if that individual was married to them, a surviving spouse, if they are over 50 years old and disabled themselves, they can get benefits from the disabled spouse. If the individual, the surviving widow or widower, is not disabled, they have to be 60 years old or over, but then they could also receive benefits through the survivor. And that comes in handy when the survivor doesn't have enough quarters or their social security rate would be quite low. Perhaps the deceased had more quarters and more pay in the system, and that could definitely help. So children, there's a whole other set of rules for being found disabled. We call that the 6 domains, but it's very similar in the sense that all the advice all of us have given today kind of applies to that, the same type of case. So there's a lot to it, but in a nutshell, yes, a child can apply. There's just a couple other things that you got to look at.
Thanks. Okay, let's see, next question. So Ken, this one might be for you. A lot of doctor's appointments out there are pretty short, and so it's really hard for patients to cover everything they need. And then to add the conversation about disability and how patients are doing, do you have any strategies for how to go about that?
Well, obviously you need time with the doctor. And so probably, and Ron might have some ideas, you do need to ask the doctor at some point at an appointment before you're going to apply if the doctor will support your application and your case. And maybe the doctor could schedule, some extra time for such an appointment. Often doctors will charge for doing a disability report. Also, there's some new rules. I don't know exactly who issued them. I do have the documents that under certain circumstances for people on Medicare, Medicare will pay for a doctor's extra time at an appointment if a person has some kind of chronic illness. And we can provide that information on our website or by email to people. Yeah, the problem, of course, is short appointments. But for Social Security disability, you have to get a little extra time to go through with the doctor what he or she needs to do. Ron, do you have any opinion on that?
Yes, I would agree with all that. I think judges, from what I'm seeing, are more open to, they understand that the practice of medicine has changed. You know, we're seeing a lot of nurse practitioners involved. Judges are giving those people weight to what they're helping write, as long as the underlying physician is really has all those same criteria of a lot of good treatment. So I tell clients, if you have that appointment, and you can find these forms through our resource or online, but they're called medical source statements, and bring them to the appointment, have them folded up in your purse or your pocket, and say, Judge, this is for disability. And a lot of these are one pagers, which will ask those critical questions. How many days a month would you miss? Are you off task from focusing? And if your doctor has even 5 minutes at the end of the appointment, that could be the difference of your case. So I would say, come armed and ready, and never tell a doctor, I'm getting this for a lawyer, or I'm getting this for this court case I have come up. Oh, the doctor will want nothing to do with that. Doctors don't really like lawyers. I mean, let's be honest, sometimes that can happen, and that's okay. But make it about yourself, which is the truth, which is, this is for me. This is for my daughter, my son, something. And I think that your odds of getting it back are much better.
Bob, do you have any quick comment from your experience?
Oh, Bob, you're muted.
No, I don't think so, Ken. I think you guys summed it up pretty well. I think with in Roby's case, back 5 years ago, we really didn't have many options. And when you think about the numbers of people in Massachusetts that potentially have ME, maybe 50,000, and you talk about the number of doctors that can talk the subject, it was kind of a difficult thing to do. So she ended up going to my PCP, and she was comfortable with her being a female. And, she said she would do everything she could to help, and she did to a certain extent by signing that letter for us. And she filled out that 6-page application, I guess, and she noted that all the conditions for my daughter were extreme. So she did what she could, but again, back then there were limited resources, and I think we still might have that issue today.
Great, thank you all. Okay, we have another question. How much documentation is too much, or what is the right level of documentation, especially for someone who has been ill, maybe a decade or more?
Give that to Ron, I think.
Sorry.
Yeah, I would say you can never have enough. Sometimes you can overwhelm a judge in a good way with documentations. We've gotten to the hearing level sometimes where there's literally 3,000, 4,000, 5,000 pages of medicals, and I'd much rather have that than less. So I would say, it depends. If the documents are really ongoing office visits and things of that nature, great, bring them, all of them. So I don't think, I would say letters from family supporting, like sort of non-medical exhibits, I wouldn't go too many with that. That's really what the hearing at that last stage is for. But I would say if it's really your medical records, the more the merrier is the way that I say it. Yeah.
Yeah, I would just add to that. I mean, I've heard over the years that some patients are very precise and want to cover everything. So they might write out a 30 or 40 page answers to questions. And I've heard that some examiners and judges will say, gee, if this person can do this, maybe they could do a sedentary job. Do you have any comments on that, this is from the patient now, not from medical sources. I have heard also sometimes it's good for patients to keep diaries of their symptoms and their daily activities. Do you want to comment on that briefly, Ron?
Yeah, it can cut both directions. Remember, if it's a non-medical, and what we're talking about here for the audience is really, as you apply, if you're not familiar with it, there's certain sections for remarks and your own words answering certain things. So sometimes if there's too much there, it could open up certain cans of worms. In other words, judges will look to those answers and they'll really study them for things like vacations or walking a dog, or they're trying to find, or exercising at a gym, for example. They're looking for things they can talk about. So I would keep those to the point as a strategy, but definitely detailed in terms of always focus on your own limitations, I would say.
Great, thank you guys. Okay, another question we have is around consistency of treatment. And I think this especially applies to ME, where there are no FDA approved treatments. And so what do you do when you can't keep going to the doctor because they're not going to offer you a treatment? Do you just check in and let them know how your symptoms are every couple of months, or what should that look like?
Yeah, I'll answer that first and very quickly, and then hand it over to Ron. When you're applying for Social Security, and also afterwards, when reviews may come up every 2 years or something, they want to know, Social Security wants to know that you are seeing your doctor, so that they can document, so that you and your doctors can document your ongoing disability. And I always urge people, see your doctor every 3 to 6 months if you're on disability, maybe 6 months, so that you can check in with your doctor. Your doctor can document your ongoing symptoms and illness and inability to work. Because if a review comes up, especially, and you haven't been to the doctor, and Social Security asks you, how many times have you seen your doctor? Let's see your current records, your longitudinal records over the past couple of years, and you don't have anything, then you could be in trouble. Ron, do you want to take the rest of it?
Yeah, I would just say, to answer the question, really just never give up. If you feel you're with a doctor that can't offer much, and I'll have clients every week say to me, well, I can't go back to this doctor. They straight up told me there's nothing they can do for me. I would urge talking to our association, others in patient services, and finding another doctor, because that judge, and when you're in the context of applying for this stuff, they're really going to look to see that you just don't give up. And I think that would be my answer to that question.
Thank you, guys. Okay. How important is it that your client attends the court hearings, and is that going to affect the likelihood of them winning their case?
In terms of, I think the individual might be asking, is it better to show up to a hearing in person versus telephone or a video? I would say, if that's the question, that there's no real difference right now. You can't do a hearing without being on one of those 3 platforms, in other words. So the judge will not let a lawyer or a representative handle that entire process. You literally do have to be answering the questions, or the judge will continue the hearing until that person shows up. And if they didn't show up a second time, they would eventually actually dismiss the case. So it is a requirement to be there in some format, whether that's telephone, which works fine, or video, which is even better, or you can now ask through the pandemic for in person, but it's an absolute requirement that you're there.
And just one follow-up to that, just what happens if, so many ME patients may be housebound or bedbound even. And so what if somebody is too ill to make it to their hearing? What happens then?
Yes, what I'll do in that scenario is I will document it. I will have the family member take photographic evidence of a person and how they spend, if they're in a certain setup of their house, we'll take pictures of that. We'll submit that as a non-medical exhibit in conjunction with a letter that I would write asking this case to be awarded. I would say, Judge, this individual cannot even attend this hearing, and here's some evidence to show that. So that has come up, and we've fought very hard. If the judge doesn't really go for that, it would probably have to be a telephone hearing, but in some manner, that judge would have to talk to that person at one point or another.
Yeah, if I could just interject, I mean, you say there's some video hearings. So,
Yep.
I mean, if a video camera could be gotten into the bedroom, the judge could see exactly what the problem is.
Right.
I don't know if that's if I'm just being quixotic about that or not, but
No, that's possible. Yep.
Okay, and another question we have is regarding the financial side of things, and I think this is related to SSI. How far in advance would one need to shed their assets to be under that $2,000 limit? And especially for, maybe the person is a child who's going to be applying for this, or somebody who was disabled at that time.
So when you get the application in, the difference between SSDI, the one with the work credits, and SSI, where you don't need quarters, is with SSI, you can't go back in time. When you apply it, that start date of benefits is from the date of application. So to answer the question, how soon would you have to shed the assets? It would have to be at the moment, really, you apply and going forward. They're never going to look into the past because, remember, Social Security can't pay past benefits. If you have work history, the nice thing is with SSDI, you can go back 1 year prior to the date that you've applied. So that is the big difference. So on the asset question, the local office examines each case to make sure whether someone has that level of assets. Now, they can look at things that are almost you wouldn't think are assets, such as getting free rent from a family member can factor it in, having a car. There's so many things that they look at. So that's a great question, and it's really just case by case analysis on that.
just to ask you a question, Ron. I understand with SSI, if you have a car, you can keep it if it's under a certain value, and you can keep your own home or abode. I'm not sure about that, but I believe I've read that. Also with, is it with SSI or just Medicaid? There's like a 5-year look back on assets. Is that just with Medicaid or does that include SSI?
No, that's Medicaid. Yeah, SSI, it's really from the application point forward, all those different, that level of, an easy rule of thumb is they're just looking to see really no assets. You know, if a person has a 401k or a person's receiving an old pension, if a person is married and their spouse works, but they don't, those are assets. And the spouse working, unfortunately, I have so many cases I want to help out on, and I just can't. The individual applying has not worked, say, in 10 years, and they're chronically ill. But if they have a spouse who's making money for the family household income, that individual is likely not going to be eligible. And that's a common problem that is very, very sad, because there's really no way around being eligible. If you don't have the work history, again, 5 out of the last 10 years of work, and say you're married and your spouse is working, but you haven't, SSI and SSDI are going to be out, unfortunately.
I'm just going to mention also in the future, we're going to have a volunteer coming on who is a paralegal who knows a lot about SSI and can help people with SSI. So if you have questions about SSI in the future, just contact the association. Also, I don't mean to belabor this question, but some patients getting on SSI have been able to set up some kind of trust where they can put their assets. But maybe that's, again, you can contact the association. We'll let you know about that.
Okay, Bob, a question for you. So if you were going through the process again, what are some things that you would be sure to do again that you did the first time? And are there any changes that you think you would make to what your process was?
Sure. So as I mentioned in the talk, I think, you know, from the get-go, we'd be a little more careful about what we were expecting our doctors, that we gave the list of doctors to Social Security and they communicated with them. We were going to be more on top of it than we were. I don't think we did enough due diligence. I think we sort of trusted the system and the system just didn't work for us. And I think, you know, just, you know, keeping the faith that somewhere down the line is a positive thing that's going to happen. And for us, it did take the 18 months, but I got to tell you, I've talked to other people with stories of 4 years, and you know, it took them that much time. So it's just, you know, keep going straight ahead, and you know, be careful, document everything, and you know, I think as one of the two guys just mentioned, make sure that the doctor's on board. And for us, the PCP was very accommodating. She was very sympathetic towards my daughter's cause. She didn't know that much about the disease, but she was ready to, you know, to help support it. And I think that's another good cause as well.
Yeah, just on that, I would say, you know, some doctors' offices, their office manager or whatever, they don't get the records in on time. So I would suggest, and we do suggest this, that people get copies of their records, and even if they're duplicated at Social Security, send your copies in. Make sure that the examiners get the documentation on time, because they have a time frame for making a decision. And also just, you know, check with your doctor's office manager, with your doctor, and just say, you know, these records need to be in by such and such a time.
And I'll just add to that, what's great law in Massachusetts is if you're applying for Social Security, all records are free, okay? Never do you pay for these records, and that's state law. So keep that in mind. If you're advocating and applying for yourself, you should never be charged for your own medical records in this state.
All right, and I think we have a clarifying question. So if you are married or if your income is coming in from another source, does that affect SSDI or just SSI?
If you're married and you have income from another source.
Or just maybe if you're married and you have
Yep.
that income also.
So with SSDI, there's no limit on household income. So in other words, let's assume you've applied for benefits, you're on SSDI benefits, meaning you have a work history, you applied and then you were found disabled. There's no restrictions on how much money that you have in an account or how much a spouse or a family member is making for the household at all. There's just a limit on what you personally can make, which I outlined in that last slide, which was the substantial gainful activity level. So as long as you're not working, the household could have really an unlimited amount coming in. It's with SSI that the assets are critical, that they remain near zero almost, which is difficult, but that's what that law is for, unfortunately.
And the income also from a spouse or any other income coming in also applies to the claimant, I understand. So if your wife, say, is making, you know, $2,000 a month, then you're probably not eligible for SSI. That's my understanding.
Yep, I agree with that. Yes.
And does self-employment affect this at all? Or what about cases where maybe you're getting a stipend for your work, but maybe, let's say you're a grad student and you're getting a stipend for being a teaching assistant or attending the school. Are either of those two cases going to affect things?
Self-employment, that question comes up a lot. It depends. So with law, so many answers are, it depends. But with self-employment, it depends if you're paying Social Security taxes, payroll taxes. So a lot of times you don't have to do that. You could pay yourself differently. You could have an LLC, for example, that you're not paying per se, FICA taxes, but you're still completely above board with the IRS. You're not going to have the ability to really apply because you're not paying into the Social Security system. And you could possibly still apply for SSI, but again, you have to have really near zero assets. So if, let's assume you're a self-employed person who has paid in, of course, you're going to be eligible for accruing those quarters just like anybody else. And that's a great question.
Okay, I think we're getting to the end of our program here, so I'll ask one last question here, and it's about choosing an attorney. So would you have to choose an attorney from the state that you're applying from or where you worked? Are there rules about licenses and things like that patients should be aware of?
Yeah, I think everyone should choose me. I'm the only lawyer that does this. No, I'm kidding. That's a great question. So there's really no rules on that. There's hundreds and hundreds of great lawyers in Massachusetts and throughout the whole country that practice this. There's also non-lawyer representatives that have taken lots of testing in order to facilitate cases. So just do your homework. I would say referrals are a great way if you've spoken to someone who's had a good result with somebody, but there's no rules really on it. I would urge people to avoid a out-of-state lawyer. I told you in the beginning, I was one of them for about 5 years. So I would travel the country doing this. The disadvantage that I've seen, and I'll be honest, is you lose home field advantage with the judge. So I'll be in, say, Texas, and the judges don't like that perhaps I'm taking business away from a local lawyer. And I think that hurts, to be completely honest. So I would say if you're Googling or something and you find an attorney, make sure you know where they're located. There's some great national firms, but just, I would say home field advantage is something that you probably want.
And I would just add, our association does have an attorney referral list based on feedback from people who've applied, who found that a lawyer was quite helpful to them. And I always say, make sure you get a lawyer who knows something about your illnesses, because that allows them to explain to the judges the details. Also, for very complicated cases, there are some national law firms that specialize in ME/CFS and some of the other illnesses we're talking about today. So those shouldn't be excluded, but generally the home field advantage thing is quite important. So if you're looking for a lawyer, don't just open up the phone book. Find out from somebody else who knows about the illness, who's had an attorney who was successful, or get in touch with the association and we can go to our referral list.
Great, thank you. And again, I just want to thank all three of you for being able to be here today and sharing so much information with us and being able to answer all of these questions. So I'm really grateful for all of you.
Can I ask you, are we keeping the questions so that if there are questions that weren't answered, we could answer them by email or something like that?
Mm-hmm. Yeah, we have a list here, so we can answer some of those that came in that we didn't have a chance to get to today.
And Ron and Bob, would you be willing to help with that if we do that?
Yeah, certainly.
Yeah.
Thank you. Thank you. So I just want to remind you again that the recording is going to be posted on the MassME CFS YouTube channel. So we will get that out as soon as we can, and we'll also post the slides on our website. So if there's something that you missed and you want to go back, that will be available to you. And I
also mention that we do at MassME CFS, we do disability counseling. We do help you find resources and so forth. So you can always get in touch with us through our website.
Mm-hmm. Yes, so you can go to the website and there'll be a contact us link there, and you can reach out if you have any questions or if you're interested in getting some additional information for your specific case. And we have some resources for that. I also just want to alert you that we will be having our next Sunday conversation next month on March 20th. So these sessions are on the third Sunday of the month at 4 p.m. Eastern. And next time we will be covering a functional medicine approach to complex chronic illness, which will be presented by Dr. Andrew Lenhart, who is a physician in Beverly, Massachusetts. Also, if you have any ideas for future programs or speakers, we welcome those always. And so you can email us at events@massmecfs.org and let us know what kind of topics you'd be interested in hearing about. And these conversations are really meant to provide practical information that patients can use in their daily lives. So again, if there's a topic you really want to hear about it, let us know. And finally, if you found this program worthwhile today, there are a few ways you can help out. You may make a donation to help support the series by donating online at massmecfs.org/donate. And on that same page, you can sign up for our newsletter. And if you donate $25 or more and check the Become a Member option, you'll also be able to hear about some of our members-only accounts, or members-only programs that occur periodically throughout the year. And the newsletter is just a great source of information to hear about goings-on or events in the ME/CFS community. So once again, I would really like to thank all of you for coming today, and we hope to see you again next month. So thank you. Bye-bye.